Good afternoon and welcome to the Appellate Division First Department. We have a little out of order today because it is Justice Kern's last sitting as an appellate division, or any judge, I think, right? So I'm going to say a couple of things, and that is, as the next most senior judge on today's panel, and also as a longtime friend and colleague to our presiding justice, our justice presiding, I should say, it's my honor and my pleasure to give some brief remarks on Justice Kern's career and her accomplishments. Justice Kern's time as a judge has spanned more than 25 years. She doesn't even look like she's 25. It's a miracle that she's been on the bench more than 25 years. She leaves the bench with a proud and well-deserved legacy of public service and judicial integrity. Justice Kern started her legal career as a commercial litigator. And in 1992, she became principal court attorney to Justice Joan Lobis, and she never looked back. 8 years later, in 2000, she was elected to the civil court, and then 2010, she was elected to the Supreme Court. And in a brilliant move, in 2017, the governor appointed her to the Appellate Division First Department. Since that time, Justice Kern has been an integral part of our court, ensuring consistent and practical precedents that make sense in a quickly changing legal world. Justice Kern's colleagues have always admired and respected her for her careful, deliberative approach to every appeal, her insightful opinions, which are valued by the bench and the bar, and her longtime commitment and lifelong commitment to justice. All of us on this panel have sat with Judge Kern for 25 years or more, and all of us on the panel and all of us in the courtroom and all of us in the entire First Department community say to you, congratulations, Justice Kern. Well done.
You would never guess from my tears that this is actually my choice and my decision to be leaving, which it is. And I'm excited about leaving, but I'm also sad because this has been such a privilege and an honor to be part of the First Department, to have had this opportunity. Before I go, I just want to say, I'm also going to do a sitting today, but I want to say a very, very special thank you to the wonderful people I have worked with here at the First Department who have made this institution the excellent and wonderful place that it is. The clerk's office, the court officers, the law department, the motion and editing department, IT, HR, the custodians, the court attorneys for the justices, my fellow justices, and my two excellent court attorneys, Alex and Ariana. It is the people here who make this place so special, and is what I'm going to miss the most, the wonderful people that I've worked with over the years. So thank you. And now on to business. We have 7 hours of argument time requested. So only ask for the time that you need, not the time that you wish. And I will call the calendar now. People versus Gale. Appellate? Respondent? 4, 1, and 3. Perez versus Norman's K Group. Appellant? Okay, just in time. How much time are you requesting? Respondent? 5, 1, and 3. Gale versus Jasmine is submitted. Mendez versus City of New York. Appellant? Respondent? 4, 2, and 5. Richardson versus City of New York, appellant? Respondent? 5, 2, and 4. People versus Page is submitted. Norris versus,
Leon.
oh, I'm sorry. Leon versus Plaza Construction, appellant? Why do I have it down already? Respondent?
Respondent, defendant, appellant. 3 and 2, Your Honor.
Do you have a cross appeal? Yes. 5, 2, and 3 and 2. People versus Page is submitted. Norris versus Integral Yoga Institute, appellant? Are you the appellant or the respondent? Do you wish to submit or do you wish to? Okay, it's submitted. AV and Co. New York versus certain underwriters, appellant? Sorry.
The appellant requests 7 minutes and 3.
Respondent? 5 minutes, Your Honor. 6, 1, and 5. People versus Gonzalez, appellant? That is submitted. Cohen versus Cohen, appellant? 6, 1, and 5. Brown versus Hossein, appellant? Respondent? 6, 1, and 3. Century First Credit versus Priority Capital?
Appellant, 3 minutes, but respondent is in argument, so I will having side observation.
You know, we'll give you the 3 minutes. Did people want argument? Yeah, we'll give you the time. People versus Morton, appellant? It's submitted. People versus Cuevas, appellant? Respondent? 4, 1, and 4. Brittany versus Gustav, appellant? Respondent? 5, 2, and 5. And 3. Callan versus RCB3 nominee, appellant? Respondent? 5, 1, 4, and 5. People versus Andujar, appellant? That is submitted, and Brown versus City of New York is submitted. So our first case will be People versus Gale.
Good afternoon, Your Honors. May it please the Court, Desiree Sheridan for Appellant Horatio Gale. Your Honors, in this particular case, the order of protection exceeded the statutory minimum by almost 3.5 years. Mr. Gale was sentenced, or actually his sentence was to run nunc-pro-tunc to October 18th of 2019. Consequently, he was sentenced to 1.5 to 3 years, and so his maximum expiration on that sentence would have been October 18th, 2021. And pursuant to the statute for orders of protection, the order of protection should have expired on October 18th of 2029. However, in this case, the order of protection is set to expire on February 25th, 2031. So that's nearly 3.5 years too long, and under the circumstances, the order of protection should be modified or amended to reflect the proper date of October 18th, 2029. In terms of arguments that my adversary has made regarding the sentencing that took place on February 25th, 2020, it was very clear at that sentencing that the sentence was going to run nunc-pro-tunc. The judge mentioned it several times.
So are you asking us to make the change in the, to the actual date? Or are you asking us to remand it for further determination by Supreme Court as to the time for the maximum time?
I would say that you could correct it in other cases in other departments where this has occurred. The appellate division has corrected it. So I would say that it's certainly within, your realm of power to do that. Alternatively, then I would ask that you send it back to have it corrected, because as it stands now, on its face, this is clearly not the correct end date for the order of protection. And certainly Mr. Gale should not be subjected to any additional time besides what the statute authorizes. And so I think either of those solutions or remedies would be fine. But clearly, the date of February 25th, 2031 is not correct. And you can even tell from the sentencing minutes, he'd already begun serving his sentence on this case, because at one point, defense counsel even says he's already begun serving his sentence on this case. So certainly, the February 26th sentence date is
We're
not
talking about resentencing, right? He was sentenced, but you're talking about when he was resentenced.
correct. My adversary is arguing that the date that it should run from was that resentencing date in February, but he clearly already started serving the sentence.
Wouldn't it be better for us to send it back to Supreme Court to figure that out?
I mean, I don't know, because the judge who did this, it was Judge Mitchell, and so he was very well aware of the nunc-pro-tunc date, and he was very well aware of all the dates involved, and nevertheless.
Except, yeah, so, I mean, that's your argument, right? But the order doesn't reflect what you're saying he was very well aware of, right?
Well, that's why I felt like, I would feel like it might be just an exercise in futility to have sent it,
The
to send
argument's
it
not
back.
preserved, it wasn't raised below, right? So it wasn't like the lawyer made the argument and the court rejected it, it wasn't made.
Well, in this case, and I would actually refer to the third department case I cited, of People versus Clark, there was really no opportunity for counsel to do anything.
Right, but you're saying it's futile, but it wasn't even raised, the court never had an opportunity to correct it if it was an error. So why shouldn't we remand it, I guess is the question.
Well, I guess I
The
would,
court could have an opportunity.
submit that it would be futile, because it was clear the judge was aware of all the dates involved here still,
you.
and was very intentional about making it.
I'm sorry, if we decide that you're right, then the court going to have to follow it, right?
That's correct, they will have to, yes.
Thank you.
May it please the court, Oliver Lee for the people. Good afternoon, everyone. Your Honors, there is no need to remand this case. Nunc-pro-tunc directive does not automatically change the commencement date of defendant's sentence. Defendant had to serve his sentence for this case consecutively to the undischarged time for his prior felony conviction, because he was adjudicated a second felony.
So, I mean, it's kind of, that's the problem. It's not really clear, so that's what the judge intended. But the transcript, the second time around, the resentencing, I think, was kind of hectic, and it's not really clear. So just wouldn't it be better to send it back down to make that clear?
Well, Your Honors, I think the transcript does make it clear that the sentence had to have been done consecutively rather than concurrently. That's why they had to resentence him.
Right, that's why they had to resentence him, but the question is whether the order of protection goes to what date does it go nunc-pro-tunc, right?
Sure.
And it's unclear, I think, from the record what the judge was thinking on that.
Well, Your Honors, we know, based on People v. Johnson, that defendant would not be credited for the nunc-pro-tunc date. Whatever date that they were requesting for nunc-pro-tunc, it had no effect on his actual sentence that he served. So based on the judge's intention to make the order of protection from the resentencing date, it seems clear that that's what he wanted.
Well, I think well, I don't know. The counsel's arguing it's clear from the record that he wanted it to have it go back to the first sentencing date and not the resentencing date. That's the whole point, right?
Understood, Your Honor. That being said, defendant is procedurally barred from making these arguments anyway. He was told of the resentencing date, he was told of the expiration date for the order of protection at the end of the proceeding. He didn't make any argument about it. Additionally, he also validly waived his right to appeal.
Yeah, but that's a sentencing issue, right? Isn't this order of protection part of sentencing which survives a waiver?
Yes, Your Honor, definitely. So this court doesn't even need to reach the issue and could affirm based on those 2 points. And Your Honors, if there are no further questions.
Thank you.
I just wanted to briefly say that Johnson was a very different case that involved jail time credit under 7030, where you can't get double dipping essentially if you're serving a sentence already. You can't have that time applied to the previous sentence and to the new sentence. So it's not what's happening in this case, which is non-protunct for when he was arraigned. I would also argue that the appeal waiver does not prevent you from addressing this issue, because the waiver said very specifically it applied to sentence and conviction, and this is neither of those situations. This is an animal unto itself, so the waiver should not be applied to this order of protection issue. And moreover, I believe that the date that he was going back to was his arraignment date, which was the October 18th date. And so from that date, I think, is when he meant the sentence to run nunc-pro-tunct. So I certainly think that it is reviewable by this court, or alternatively should be sent back to the trial court to correct its error. And if there are no further questions, I will rest on my brief.
Perez versus Norman K Group.
Thank you, Your Honors. Good afternoon. Your Honors, the defendants appeal this on a variety of reasons as outlined further in our brief. Principally,
Let me start on a procedural issue, which could be a dispositive issue.
Sure.
Which is that this was granted on default. And normally the rule is when something was granted on default, you have to move to vacate it, and then you get to appeal the denial of the motion to vacate if it's denied. But that never happened here. So why is this an appealable order since it was clearly granted on default?
That's a good question, Your Honor. Relative to James v. Powell, that was actually cited by the plaintiff in this matter. This was a motion that was contested as well as briefed.
It was contested and briefed, but the court was very clear in its determination that it was not deciding this case on the merits, that it was deciding it based no appearance move-in. So the court never gave any reasons or elucidated why it was ruling why it did. It just denied it because the move-in did not appear. So it's clear from the record that the decision, although arguments were clearly made and it was briefed, that that's not how the court decided it. The court decided it on default.
Your Honor, relative to that same case in James v. Powell, at that point in time, the plaintiff should have motioned to have it dismissed based on such default, but they never did. And as-
The issue is when you appeared, you failed to appear for oral argument, and under 202.27 or 22 NYCRR 202.27, which deals with defaults, a failure to appear is a default. And as my colleague pointed out, then your next step would have been to make a motion to vacate the default, saying, look, we forgot the calendar, or say whatever you had to say. But the real issue is, can you be here now on the merits?
According to James v. Powell, we can, Your Honor.
How are you
Well,
distinguishing-
according to Spallone v. Spallone of this court, you can. So I guess we have a bit of a conundrum here.
No, the problem is because the court didn't decide on the merits, the court didn't issue a decision, so there's really nothing for us to review because there's no analysis by the court below on the merits. So what are we left to review then in that situation?
Well, we believe that you do have the ability to review based upon the fact that it was previously briefed and there wasn't any additional moving to have it dismissed.
Well, what could we review? The judge the judge below didn't make any substantive decisions. So we would have to do it in the first instance, which we generally don't do on appeals, right?
Well, so, Your Honor,
Let me ask you
Relative to
that, let
Mizan.
me ask you in a different way. What did the judge below get wrong?
in our opinion, Your Honor, the judge below did not review anything of substance and
So
just
you're
indicated
saying that the thing that she did wrong was issue a default,
Correct.
right? the way, but again, right, we can't review that. That is not an appealable order.
Well, based upon Maison, as well as James B. Powell, we do have the right, because even in Maison, there was no application to the instant case, and it was therefore an opportunity to be heard based on submission at that point. And since there wasn't any further action taken by the plaintiffs in this,
So, I mean, isn't that what you want to say to the judge below, is you should have issued a decision on the merits because we submitted? It's not for us, it's for the judge below. What you're arguing is to the judge, the trial court judge, you should have issued a judgment, you should have, on the merits because we submitted papers. That's not for us to decide. That's for the judge below to decide.
I understand, Your Honor, but she still did issue a determination,
What was the determination?
denied.
On what grounds?
We didn't show up,
Right.
although we were notified.
So there you go. The grounds was default, nothing on the merits. I mean, I feel like I'm beating a dead horse, so I'm going to let it go.
Your time's up anyway, so let's hear from opposing counsel.
Good afternoon, Justices. I'll reserve a few seconds to say congratulations to you, Judge Kern, and thank you for your service. I don't believe I have anything much to add to what the justices have expounded on, so I'll leave my time.
Okay.
Thank you.
Thank you.
You have another minute if you wish it. Or you can waive it if you wish.
Well, I'm sorry.
Or you can waive it if you wish. It's up to you, since he didn't say anything, but.
The only thing that I would further stress is in James, the Court of Appeals found that CPLR 5501 wasn't applicable and did not bar the defendants from appealing. And that the statute provided that an aggrieved party may appeal from an appealable judgment or order except when entered upon default of such aggrieved party that did not bar the defense in action for interference with collection of a judgment from appealing, based on James. Which means that in the event we had the right to appeal, which we believe we did based on the cases of Maison and James, at that point in time, plaintiffs should have filed a motion in this court to have it remanded,
Thank you.
and they did not.
Thank you. Mendez versus City of New York.
Good afternoon, Your Honors. May it please the court. Jack Lockwood for the plaintiff appellant. I would just like to start out by congratulating Justice Presiding Kern and say, I think I speak for everyone here, that it's always a pleasure and honor to appear in front of you, and you will be sorely missed.
Thank you.
To my argument, Supreme Court erred in granting defendant's motion to dismiss the federal cause of action as time barred insofar as asserted against the John Doe defendants, Gloa, Montera, and Lattimore. The court should have applied the John Doe designations authorized by CPLR 1024, and the Supreme Court also should have applied the relation back doctrine authorized by CPLR
Counsel,
203C.
Could you address specifically the issue of whether or not due diligence was used in attempting to ascertain the identity of the defendants before
Yes,
the
Your Honor.
statute of limitations
So I think
expired?
with respect to the CPLR 1024, due diligence is obviously the second prong. This is the main contention in this case. The Supreme Court, we believe, incorrectly determined that the plaintiff had all of the body-worn camera footage as of May 2021, and that they could have ID'd.
Well, let me ask a more specific question.
Sure.
Up to and until the time that the statute of limitations actually expired, Were there any efforts that the plaintiff took to identify the officers other than the FOIL requests?
Yes, Your Honor. There were, of course, the FOIL requests, and I did want to touch on that those did specifically ask for, quote, the complete file regarding arrest and prosecution. Also,
Okay, but the FOIL request wasn't directed to the city, right? That was directed to someone else. But
was
what, the
directed to-
question is, I think, is what did you do with respect to the city, other than show up at those conferences?
Sure, Your Honor. So the plaintiff's attorney relied on the discovery process and the
But didn't the judge did issue a discovery order?
That's
but
correct.
But unfortunately, as sometimes happens, the defendants did not comply with those discovery orders, and that seemed to go on for years. And the plaintiffs did not make any motion or to compel or anything. I mean, it was just you'd have a conference, and then you got another date to comply, and it went on and on. So it seemed like you knew that there was an order, but did you need to do a little more than just have an order in your hand? Did you need to, bother them a little bit more and do something more formal?
Yes, Your Honor. I think with the benefit of hindsight, you can always, in every one of these cases, look back and say, yes, there were things that could have been done, certainly. Plaintiffs did attend.
But it's
all
more than hindsight, right? Because we've all sat in a city park, right? Three-quarters of the time, it's per diems that come in for the plaintiffs, and they say nothing was done, and we get another order. So it's got to be more than just that, which is all we have here, right?
Your Honor, first of all, I would just say that
Oh, it may not. I don't know.
this is not a dispositive factor
Right.
on this. The case law, there is no case that says that this is a dispositive factor or that it's necessary in order to define due diligence, that you are not allowed to rely on the discovery process. The cases where there are some cases where courts have said that you should have made motions.
Yeah, and in those cases, they denied, right? Those cases where the plaintiff didn't do anything more than just
In here, Your Honor,
rely on the
in
discovery
those cases, there were
process.
no FOIL requests either, Your
Okay,
Honor.
but again, that's not towards the city.
It is towards the NYPD and to the Bronx District
Right.
Attorney. I see my time is up.
Thank you.
Good afternoon, Your Honors. May it please the court, Hannah Sorokin for respondents, and congratulations, Your Honor.
How do you respond to the plaintiff? Look, I relied on the city to do its job, which it didn't do, clearly, because there's 4 or 5 orders saying, city hasn't complied city. Why is that? Why should the plaintiff have to do more than that?
I think this court and the second part have been quite clear that something more is required. And I think critically here, the first actual request for the identities of the Doe defendants came in June 2023. That was the first specific meaningful request, and that was after all but one.
Are you saying that all those other earlier orders, you had no idea that that was what you were being asked to supply?
I'm not saying that, but I think towards the question of whether or not the plaintiff here.
I think that's what you just said, that the first time that they really asked for this information was in 2023. And so you're saying all those earlier discovery requests that you didn't comply with, didn't ask for that information?
The discovery, the orders from the court did require the witnesses generally. It was a general discovery order. Those were, by stipulation, extended for several years. Part of this case did occur during COVID. But I think critically, the appellant here made no effort to submit their own discovery requests, did not ever seek to compel discovery. And in fact, they stipulated repeatedly to those adjournments of the court-issued order.
I wonder if you could, if you wouldn't mind getting to the relation back doctrine, and why can't putting that aside, I know there's 3 prongs, but let's not just spend it on one prong. So what about the relation back doctrine? Why would the plaintiff not be able to rely on that, assuming they did their due diligence?
I think relation back does not apply here for multiple reasons. Due diligence is a component of that doctrine, so it fails at the outset because they did not show, the appellant here did not show due diligence. In addition to that, this court has been quite clear that this type of, what they're calling a mistake is not a mistake for purposes of the relation back doctrine, just not knowing the identities of.
Well, I thought, maybe correct me, but in order for the relation back doctrine to work, there has to be unity of interests, right?
Yes, that's
Isn't that a critical component?
that is certainly for the federal claims. That is
Right, and in this instance, if you're charging the defendant, individual defendant, police officers with misconduct or tortious-like activity, the city can't be united in interest with that. Fair?
correct. It's certainly for the federal.
So that kind of vitiates the whole basis for a relation back, right?
I agree. Yes, it does, and I think also for the state claims, there's no basis here for the Doe defendants to have any indication that they would have been intended to be part of this suit, especially after 4 years had passed in this case without any suit. We cite several cases with similar cases where police officers who were, even when they were, I believe, deposed or stopped for hearings, but claims were never brought against them after several years. The court has held that there's no basis for them to know or should have known. So the relation back doctrine does not apply here quite squarely. CPLR 1024 does not apply because there were no diligent efforts. The FOIL requests, again, those weren't discovery in this case, but they also didn't specifically request the identities of the officers, and they never followed up. So they sort of claim on appeal that they didn't actually get the body-worn camera footage, even though there's links in the record. But even if that were true, due diligence would require them to follow up, bring in Article 78, submit their own, in this litigation, their own discovery requests. They simply never did that until all but one claim had run. And even when they did ascertain the identities before that federal malicious prosecution claim had run, they still failed to timely attempt to substitute the defendants. And I'd just also quickly like to note, Your Honors, the state court claims here, it was not an abuse of discretion for the Supreme Court to dismiss those as well.
Did they move? Was there a motion? Was there a specific request to dismiss those claims, or did the judge sui sponte do it?
The notice of motion sought only to dismiss the federal claims and then included a general prayer for relief, and then it was raised in the conclusion section of the, if I may just complete this answer, conclusion section of the affirmation, and then on reply, but this court has held that it also, critically, it was raised in the amended answer. So this court has held in this context that isn't sufficient to preserve this court's review, and that the court has discretion when it's clear on the face of the papers before that this would be a dispositive issue, that the court can reach those claims, even if they were not specified in the notice of motion and were just in the general prayer. Thank you, Your Honors.
Your Honors, I just wanted to point out briefly that there was a good faith letter that was sent here. That was done before the defendants actually even gave their first response, which was about 2 years late and which was also deficient. Plaintiff immediately objected to the deficiency on that. I think Your Honors can also take into account the defendant's actions here in hindering discovery. It is obvious from this record that the TRI forms, the threat resistance investigation forms that were eventually provided, which were specifically filled out by 2 of the John Doe defendants. There's a third one that we never got, that those specifically say that they were
Let me
involved.
ask you, counsel says that other than asking for witnesses, you did not, until 2023, specifically ask for the names of the John Doe defendants. What do you say to that?
I don't know how, I'm not sure that type of specific request.
I'm asking if you made it. Did you make it?
No, Your Honor, no.
You didn't?
We did not say.
Okay.
We want the names of the John
Okay.
Does until later on in the thing.
Until 2023.
However, the requests were reasonably calculated to obtain that information. And if they had complied with those requests in a timely manner, the John Doe defendants would have been substituted. We know from the record that they had these documents years before. The TRI reports were filled out by 2 of the John Does who admitted to striking the plaintiff on the date, on the time, and in the place alleged in the complaint.
Counsel, why didn't you ask for those names earlier? You said that you didn't ask until 23. What stopped you from doing so at the very beginning, at the outset? You knew that that was part of your case. You put in the John Does.
The requests that we gave were broader than that, and they encompassed the names. That was our position, and it still is. If they had responded and given us the names of all the witnesses, they don't know who the John Does are any more than we do until they do their own investigation or whatever.
Counsel, what's your response to our Powell decision? Is there a unity of interest here?
Yes, Your Honor, briefly. We believe that the case law in the past has shown sort of a mechanical interest in this. Trace it back to this court's decision in Higgins, where it says there is no vicarious liability, and because there's no vicarious liability, there is no unity of interest. That has been followed by this court in other cases. We acknowledge it in our duty of candor to this court, and the federal courts do not follow that. This court has rejected that argument as well. We acknowledge that as well. However, the most recent Court of Appeals case, the K. Tooling case, specifically says that vicarious liability is not a dispositive factor. It is not, this is not a mechanical application. Thank you, Your Honors.
Richardson versus City of New York.
Good afternoon. May it please the court. Nicholas Bruno for the appellant. The motion court incorrectly granted defendant's motion for summary judgment for 2 reasons.
Why isn't this a classic storm in progress case? Numerous times we've dismissed cases based on the storm in progress defense, and there does seem to be undisputed weather records that state there was a storm going on.
Because the storm in progress doctrine is only half of defendant's burden in this case, because there's evidence that Mr. Moore, the station cleaner, applied de-icing material to the stairs during the storm.
What about that opinion is not just conclusory, though, that somehow something could have been done differently? Like, what could have done differently to have prevented this or
The expert,
prevented this accident?
plaintiff's expert opinion?
Exactly.
Well, it's not conclusory for a number of reasons, primarily because the expert specifically reviewed photos taken by the plaintiff on the day of the accident, the weather data, and the deposition testimony, which included Michael Moore's testimony that he applied de-icing material. And they were able to conclude, and relevant to that, the weather data specifically states—
How does the expert say, this is how it was done and it was wrong, and this is the way that it should have been done, alternatively that would have prevented it? Where is that in the expert report?
They say that they concluded that applying the de-icing material allowed the ice and the snow that was ongoing to melt and then refreeze.
Right, but how are they saying it should have been handled rather than the way it was handled? Because they're not saying never use de-icing material. So
No, of
what are
course.
they saying should have been done differently?
It required more, either more ice or more frequent sand and salt, or more frequent application of sand and salt, and that makes up a majority of the expert opinion, reference to the standards of.
Well, didn't your expert apply a standard, I guess, in the industry, but nowhere is there case law that requires that standard be applied to the MTA. You agree with that, right?
I do.
So therefore, his whole discussion of what shoulda, coulda, woulda is not really applicable to the city.
Respectfully, Your Honor, we don't even get to that point because it is part of the defendant's burden, because there is testimony. It's part of defendant's burden to establish that the de-icing material that was applied did not create or exacerbate the dangerous condition, and that is defendant's burden. I'd like to direct the court to this court's case in a decision in De Los Santos, where the court dismissed defendant's summary judgment motion because there was evidence of defendant's employees' snow removal activities.
But that's for you to raise, right? Once you show that the storm is in progress and that the doctrine applies, then the only way you can defeat summary judgment is to show that there was de-icing or shoveling, and it was done negligently, right? So they met their prima facie burden. You're not just, well, I guess now on appeal for the first time, you're saying it didn't snow, but you didn't say that below, so we're not going to deal with that. They showed, they put in everything that they were supposed to put in, the meteorological data, even your client said it was snowing. So they've met their burden. Now it's your burden to say, but yet you de-iced and you did it improperly, right? That's the way the shift goes. It's
If I
not
could-
their initial burden to say anything, it's your burden.
This court's opinion, De Los Santos disagrees. If I can,
I think our decision in Baum versus Dawn Liquors, I mean, there are a lot of decisions in which we say that. So let's assume that we agree with what we said in those cases. How have you raised an issue of fact?
because as I stated, the expert had reviewed that de-icing material was applied, and defendants have not identified a case from this court that states that we need to be more specific than establishing that the de-icing material caused the snow and ice to melt and then refreeze again to exacerbate the dangerous condition.
Okay, but that doesn't even that theory doesn't even comport with what your client said. Your client didn't say there was a thin layer of ice. She said it was slushy, icy, as if it was going on. So where did the expert come up with this refrozen ice?
Based on the fact that the salt lowered the freezing temperature of the then melted snow and ice.
But your client didn't say that. Your client's the only one that was there, right? Anyway, okay, thank you.
Thank you.
Good afternoon. May it please the court, Adrian, you're on for transit. First of all, Judge Kern, congratulations. I hope you have as much success in your future endeavors as you have had here. Judge Carpula, you made most of my case for me. Yes.
Or at least
in fact,
I looked at the
Our
record.
only burden was to show it was snowing, and it was snowing like crazy, 15 inches that day.
How do you respond to the expert's report from
The expert's
Why
report-
is that insufficient?
I read all 43 pages of that expert report many, many times, and basically the expert report is saying, oh, they should have kept removing snow all day long. Well, as this court knows, we have no duty to remove snow all day long. And that's what you get when you hire an expert from out of state. Nowhere in that expert report did the expert touch even remotely on how they figured out that some application of salt some 10 to 16 hours before this accident, when it was followed by 10 or 11 inches of snow falling and people walking up and down the stairs and everything else, had anything to do whatsoever with the conditions at the time of plaintiff's.
So the expert did not, I mean, I also took a look at the report, you probably read it more than I did, but did not indicate anywhere that any of the actions that your person, Mr. Moore, or anybody else took for transit made it worse than if you had done nothing.
That's correct. I mean, most of the report really said, oh, we think that they should have kept removing snow all day long. My colleague here is focusing on literally one sentence at the very end of this report where he threw in, oh, and the salting material might have been whatever. Nowhere did they make any explanation of how they think the salting material affected it or did anything. And there's a case exactly where this was addressed. That's McCord versus Olympia, almost identical facts, where an expert literally threw in a sentence, oh, the salting material might have refrozen. And, the second department said, no, they didn't point to anything specific that showed that it made it worse. And the same thing applies here. This expert didn't point to anything that shows that our preliminary snow removal 12, 14, 16 hours before this accident and before 10 or 11 more inches of snow fell, did anything that could possibly have made this massive snowstorm worse.
Thank you.
Thank you, Your Honors.
Just briefly direct the court's attention to page 427 of the record, where it states that it's the weather data. It states that the high-low apparent temperature range for the day of the accident was between 24 and 20 degrees, which is clearly below freezing, and that tends to support the expert's opinion. And quickly, just to distinguish McCord from this present case, there the expert didn't cite specific parts of the climatological record to support their conclusion, but here the weather data directly supports the expert's conclusion. If there's no further questions, I'll rest on my brief.
Thank you very much. Leon versus Plaza Construction.
Good afternoon, Your Honors. May it please the court. Lisa Camo for the plaintiff. Now, the Supreme Court denied summary judgment actually to both parties based upon a finding that there were questions of fact as to whether plaintiff was required to work at an elevation. He testified that he was specifically instructed to work in the manner that he did, and there's evidence clearly that that was a custom and practice under various scenarios at this job site. So I would say the issue really was after plaintiff showed, prima facie through his own testimony that he was instructed to work at a height, did the defendant raise any question of fact in opposition to that? They say that—
Deal with which is not the clearest testimony, I will concede.
No.
How do you deal with Figueroa's testimony where he did say that it was not necessary to climb on a table to reach the rebar?
I think what's interesting about his testimony, he said a few different things. It was quite hard to understand in places.
Right, but
I
mixed in
found.
with all the sort of, I agree, confusing
Yeah.
things he said, he did say a few times that it wasn't necessary.
But he also said, he also acknowledged that there were times, now I think he was maybe attempting to distinguish those times, like when it had been delivered and someone's going up to cut the strap. He certainly said that there were times when workers had to go up there to do different things.
No, I mean, it was really unclear what he was saying, but he definitely disputed a lot of what the plaintiff was saying, right? And he's there, he's the boss. If you don't have to get up and you do it, then you don't have a labor law 241 claim.
What he did not dispute, and I think it's significant, he had never said that he was instructed not to do that, right? Because a lot of this case also has to do with the recalcitrant worker issue.
Yes, but we've also had cases where the person chose to do something to create a height differential where one was necessary, where one wasn't necessary, where we said that that's not a 240.
Well,
I sat on cases like that. So why don't we let the jury decide what this somewhat inconsistent testimony is? It's hard to know, right?
I would submit that a fair reading of the record, including Mr. Figueroa's testimony and his admission that there was never an instruction. I mean, also the plaintiff
You're
is
talking about it in terms of the recalcitrant worker, which is not how I was really, to be honest, viewing this case. The real question in my mind is, was there required to be elevation to do the task? So if he decided to elevate himself, but it was not required for the task, then there's a question as to whether Labor Law 240 kicks in and requires that a safety device be supplied if it's not required for the task.
I think Mr. Leon gave detailed testimony. He did say, again, that he was specifically instructed to work in that manner, and he explained why, that the way the rebars were laid up there.
Wasn't that disputed?
Right, that's the problem. His boss disputed it.
I don't think there was a specific dispute about his ability to, he said that sometimes he could do it from the ground, but he also admitted that other times the workers would go up
But how
there.
do you deal with the fact, and again, conceding that Figueroa was not the most clear witness, he did testify that none of it was necessary to do the job, that they did it, but it wasn't necessary. So
Well, but
Why doesn't that raise a factual issue?
I don't think so. I think that the plaintiff is.
I mean, but we have
complying with-
cases that say that if there's no elevated related risk, elevation related risk, except for the fact that you create one yourself without needing to, that's not a 240 case.
I would just say quickly that to me, this boils down to the plaintiff said that he had reasons that he had to work in an elevation to be able to correctly locate and hand out the rebar, that he was instructed to work that way. So if there's a conflict over whether or not that was really necessary, like his supervisor's trying to give an opinion that at that particular time he didn't really need to be doing that, but it's kind of like the Bianca-Netto case in some ways, where it's a custom and practice at the work site that's acquiesced in.
Well,
And we
I
also
mean,
have
because it appears from reading both sides' testimony, and I know there was also an issue about someone did not speak English, and so whether
the report.
yeah, and whether or not there was a proper interpretation or proper proof that there was a proper interpretation. Under these facts, I mean, we didn't dismiss the cases to the plaintiff, but we just found issues of fact, or the court found issues of fact. How do we get past that?
Well, with respect to the report, I mean, I think the report was not admissible for a number of reasons, and I don't have time to detail them, but it's in my brief. It is the translation issue. The plaintiff specifically denied making those statements, and also the report itself, it very oddly states that he either was jumping down or stepping down when the accident happened. So the report itself has internal inconsistencies. I see my time is
But
up.
that doesn't matter for its admissibility. It's a business record. If they put, the reason why they can't get it in as a business record is because there's no translation. If they did that, then it would have been a business record, and its weight would have been for
But all
whoever.
parts of it still, you still have to show the even as a business record, you still have to show that the specific statement you rely on is admissible. And here I would submit that it wasn't. It amounts to hearsay because it wasn't properly translated and the plaintiff denied making it.
Thank you.
Yes, thank you.
May it please the court? Again, the issue is, was this height?
Right, but counsel says your guy doesn't really dispute that he needed to get up on the table. And frankly, your guy's testimony is kind of all over the place. So what do you say to that?
Well, when you look at the testimony of all three witnesses in this case, they all testified that he was able to perform the job on the ground level. Additionally, there is testimony, and with the expert, that the height of the table with a pile of rebar would have been approximately chest high. So there's no reason why he couldn't look at any size of rebar.
Isn't there a dispute? I mean, you say it was 3 feet 8 inches, and your friend says possibly 4 or 5 feet, you take into consideration the ground to the top of the table and the rebar batch on top of the table, right? So that's an issue, really. I mean,
well,
you're not holding your hat on a height differential here, are you?
No, what I'm saying is he was able to perform the job from the ground without climbing on the table because it didn't go above his head. It's not like he was looking at the top of a stack above his head.
And you're saying that isn't just his supervisor, that all the witnesses?
All the witnesses testified to that conclusively.
Okay.
And additionally...
And what about when they had to go on top to untie the bundle?
That's a different job. And additionally, it wasn't a situation where that is what the plaintiff was doing at the time that he allegedly was injured. He says he was on there looking for a certain section of rebar. So he was able to perform that task on the ground. And because, by his own admission, he had to be able to move the rebar while it was on the table that they called burros, you wouldn't be able to put a rail that would prevent the rebar from moving. So if you do credit the plaintiff with what he's saying, that while he's standing on the rebar on top of the burro, the stack of rebar shifted, causing him to fall. If you have rails that prevent him from shifting the rebar, then he can't move them to find his section of rebar.
Isn't it true that Mr. Figueroa saw the plaintiff on top of the table and said nothing? Wouldn't that be like an acquiescing or a custom of how they did it? I think the record says that in other occasions it was done that way as well.
Well, no, Mr. Figueroa said he saw people climb up there when they had to cut the strap, when a new section or a new load of rebar would be transported with the strap attached. The only way you can get on top would be to actually cut it, and by climbing.
You're saying Mr. Figueroa didn't see him adjusting the rebar or doing anything else other than cutting.
Correct.
I don't remember that testimony. I thought that the testimony is he saw him a few minutes before the accident, and it didn't say anything about cutting it apart. He saw him on top of it after it was cut.
No, he indicated that he saw him a few moments before the accident happened while he was on the ground. The same thing that Mr. Godoy said. He didn't say that he saw him standing up there a couple of minutes before the accident occurred. That's the distinction.
Thank you.
Thank you, Your Honor.
Sorry. Just very quickly, the plaintiff, sorry, now I lost it. With respect to Figueroa, he did say that he was, sorry, I lost my place, trying to find the exact spot. Right, around 466, 487, and he also, again, it was a little bit of strange language where he said he had to get up there, but he also said that we need, 453, we needed to move the rebars, we needed to pass the rebars, so he jumped like that. So to me, that clearly indicates that he was aware of that practice. There is no evidence that he tried to stop it or anything like that. And specifically, again, plaintiff said he was instructed to do that. He never denied that he was instructed to do that. And as to the need, I would also respectfully submit that everybody did not say that this job could 100% be done from the ground. Mr. Leon, the man who was doing the job, said he could not because he couldn't see what he needed to get because there's no space under there. I think that's what he said. You have a bunch of different size rebars all piled up to a very significant height, and he's trying to find a specific length and hand it off. Again, I would submit that, once he gave that testimony that he was instructed to do that, there's evidence that it's the custom and practice at the job site in which the supervisor acquiesced. We also have a non-party witness who testified to seeing him up there, and he's out in plain view doing this. So I would submit that the issue is, was he recalcitrant? That is, did he
Again,
fail
you're
to
putting
follow
it
an
in
instruction?
terms of recalcitrant, but to me, was a safety device required, which is a different analysis.
Right. Well, again, I don't think anyone actually contradicted, Mr. Leon's testimony that he had, the reason that he went up there was because, why would he go up there if he could do it from the ground? He gave his reasons.
People
I know.
do.
People do crazy things, there's no doubt.
Thank you.
Thank you very much. And congratulations, Justice Kern, and all the best in the future.
Thank you.
And Your Honor, just briefly, specifically at the page 497 of the record is a testimony where Mr. Figueroa was specifically asked when he last saw Mr. Leon in that morning before the accident happened, where was he? And he indicated that he was standing on the deck on top of rebars that were on the deck, as you see in the photograph.
So how about page 466 that states that he went up there to able to move the rebars around?
Right. So at the time of the accident, he was literally on the deck. He may have climbed up there to move the things around, but...
So it's not limited only to cut the wire?
Well, what I'm saying is he may have gone up there to do it on other occasions, but he didn't have to. He elected to do that.
So the point is he was up there and Mr. Figueroa never gave him an admonishment to go down because it was unsafe.
Mr. Figueroa never testified about an admonishment. That is correct. If there's no other questions, I will cede my time.
Thank you very much.
Thank you.
AV & Co. NY versus certain underwriters.
May it please the court. My name is Dennis D'Antonio. I represent the appellant in this case. This is an insurance coverage case. It's a jeweler's block policy, which is a unique specimen of insurance. The insurance is complex. And
Counsel, cutting to the chase here, the critical section is section 5I, which is the unattended vehicle exclusion section that this whole case rides and falls on. Am I correct?
You are correct.
Okay, so the actual language itself is not ambiguous. The question is whether the paragraph somehow takes on a category of persons such as your client, a consignee versus a selling agent and all the other individuals that are identified as being part of the first part of that provision. You agree?
Yes, 100%.
So you're arguing that because your client was an independent person and not a control person, somehow this provision doesn't apply?
No, not exactly close, but not exactly. May I explain?
You could, you
Okay.
can.
So my client is the insured. That's Avi. That's who they sold the policy to. The coverage grants in the policy are for different types of losses that may occur while different people, different types of people, have merchandise. So for instance, in the policy coverage grant, which is Section 2, if the merchandise is in the possession of, and I'll call them the independents. The exact term is someone in the jewelry trade, not in the employee of the insured, not.
Yeah,
a
but
commissioned
that's not,
salesperson.
that term isn't in the policy, correct?
Oh, yeah, it is. It's right there.
Oh, it says independent?
Yeah, well, I categorize it as independent. because
That's my
rather than
point.
just-
But
Right.
there's no term, there's no individual called a consignee in the policy.
No, what the policy says is there's $400,000 worth of coverage when it's in the possession of a dealer, an individual in the jewelry trade, not including commissioned salespersons, not on the payroll of the insured, and not in the direct employee of the insured. That's the $400,000 coverage grant that was endorsed to $2 million. Then there's a coverage grant that's Section 2D, which is for $500,000, and that applies to the employees of the insured. The insured, an employee.
I'm
an
having
au-
trouble following your
I know you
argument, to be
are.
honest, because the unattached vehicle exclusion is not ambiguous. It says it applies to all loss of stock from inside a vehicle, and it doesn't say with regard to who is involved unless the individual is in a specified list, such as a UPS driver, which this person who had the possession of the jewelry was not on that list, is not like a UPS driver or a FedEx. So why doesn't the unambiguous language, which applies to all loss of stock from inside a vehicle, without regard to who's involved, apply?
Because the policy included a coverage grant to a specific category of identified individuals.
Right, but let's say everyone's covered, but then there's an exclusion if it happens inside a vehicle. That doesn't, that's not overridden by the fact that coverage might have been initially for these kind of people if it didn't happen inside a vehicle, but it did happen inside a vehicle.
Well,
It was left unattended, and there's a specific exclusion that seems to describe exactly what occurred.
Well, the best illustration of why that's not the way it would be applied is there are other exclusions in the policy that use the same entities as the unattended vehicle, and then it goes on to also apply it to dealers and persons.
Right, but here there is a specific carve-out from the unattended vehicle, but that carve-out does not include the people who had possession. So there is something specific, and it doesn't apply.
Well, Judge, if you read it that way, that means they've sold a policy of insurance where if, in fact, under the $2 million coverage grant, a dealer or individual in the jewelry trade, other than a commissioned salesman, not on the payroll of the insured, not a direct employee of the insured, who has insurance coverage for $2 million, would not be covered if he was sitting in the vehicle with another person and the vehicle was robbed, because the strict definition of the unattended vehicle applies it.
That's not what it says, counsel. That's not what the exclusion says. It says inside a vehicle if they're not there.
All right, well, Judge, the exclusion actually says a little more than that. The exclusion goes on to say, and there's a reason why underwriters put words into the exclusions. It says loss or damage to stock insured while in or upon an automobile or in any other vehicle, unless at the time of loss the damage occurs, there is actually in or upon such vehicle, and if it said a person, then we're not here today, then there's no coverage. But it doesn't. They restrict it with the words that follow, which the court has to recognize. Those words which restrict the application are in or upon the vehicle, either the insured, an employee, an officer of the insured, a commissioned salesperson or selling agent, or a person whose sole duty it is to attend the vehicle.
So if that person, one of those identified people, were in the vehicle at the time, then they would have gotten the coverage.
No, well, no, it would be an unattended vehicle, but it would not be an unattended vehicle
Right.
if one of those persons were there.
Right, but if it is an unattended vehicle, which it was in this case, then the exclusion applies.
It doesn't apply to the coverage grant for the $2 million to the specific different category of person. And just follow this with me, Your Honor, for a moment. If you read the clause the way it's being urged upon you, that would render the coverage illusory because you've given them $2 million worth of insurance and you've named the category of entities that have the $2 million of insurance that are not named in
But
the
they shouldn't
unattended
leave it
vehicle clause.
unattended.
Thank you. We understand your argument. We'll let you respond in your rebuttal time. We understand what you're arguing.
Thank you.
Good afternoon. May it please the court, my name is Dennis Wade. I act for the underwriters. And let me doff my imaginary cap to Justice Kern in honor and congratulations. Let me begin by saying 35 years ago, a distinguished panel of this court on identical facts and on virtually identical wording held that the unattended vehicle exclusion reached goods in the hands of a consignee. And when we argued the case before Justice James...
Are you talking about the SUFA decision?
I'm sorry, sir?
The SUFA decision, I don't know if I'm pronouncing it correctly. SOUFEH versus Reliance.
Yes, SUFE versus
SUFE, I'm sorry.
Reliance Insurance.
It's not
And when we were arguing the case before Justice James, my friend, Mr. D'Antonio, rightly pointed out, Your Honor, we can't rely on SUFE because we don't know precisely
Doesn't say
what
very
the
much in
wording
the
was.
opinion, yeah.
Then one of my colleagues searched the dusty archives of the New York Supreme Court to find the wording that was before Justice Greenfield in SUFE, and it is identical. It has that key appositional clause, comma, or a person whose sole duty it is to attend the vehicle. There's nothing about categories. The underwriters wanted to make certain that not only the insured, but anyone who was entrusted with insured property did not leave the vehicle unattended. Here, on admitted facts, Messrs. Cologne and Loyola left the car and went about other business totally unrelated to the insured. In fact, they didn't even know the car was broken into until they happened upon the vehicle and saw a police officer writing up a car burglary. I mean, these are all the facts.
Counsel, your friend made much of the fact that the insured got a bigger premium, a $2 million premium to cover the particular jewels in question and watches in question. Does that make a difference here?
No, and Justice Schulman, I am absolutely grateful for you raising that question. Because if you look at page 63 of the record, the contract of insurance, where under 2B4 memo coverage is granted, it says, and I quote, in respect of stock while in the custody of a dealer or individual in the jewelry trade, other than a commissioned salesman or selling agents, and not on the payroll or in the direct employ of the insured, subject to the conditions within. I invite you to look at the entire contract of insurance, which begins on page 63. it's not really a bespoke policy. Every coverage grant in this policy says subject to the terms and conditions within. And one of the terms and conditions within, of course, is the 5I exclusion for goods left unattended in a vehicle. And to further answer your question, Justice Schulman, why would the underwriters choose to give a consignee greater coverage than the insured had himself?
Right. They don't know the consignee, right? They don't know what they have no ability to regulate or that the consignee's actions or activities, right? Where they might on their own clients and their own employees.
Well, it's true, they're not under the direct supervision, but there is a memo of insurance.
Right.
And everything is subject to terms and conditions within the policy. To just wrap up, even though the red light blinked,
No, your time's up. We got your arguments. Thank you
this
so
court
much.
ruled in 1990 in
We have
Souffet,
it.
that's good law. Justice Greenfield's decision is good law.
Thank you,
And
counsel.
Justice
We
James.
understand. We have it.
Thank you,
Thank
Your
you.
Honor. Thank you all.
It sounds like you're winning, you should stop talking.
What?
That would be a mistake to apply the policy the way they're asking to. I don't know how to state it more bluntly. If you look at the paragraph that grants coverage for the $2 million in this policy, it says that there's going to be coverage for $2 million while it's in the custody, and it names 3 categories of selling agents. None of those categories are delineated in the unattended vehicle endorsement or exclusion. And the principle that governs insurance policies would be that if the underwriter wrote into the unattended vehicle exclusion the words that it has to be attended by, and then it names entities that are not in the grant of coverage, the separate grant of coverage, you can't apply it to them because it would make the coverage illusory. Because
How do you respond to your colleague's suggestion that if that's the case, they would have greater rights than the insured?
Well, they have no rights. It's the insured that sustains the loss and makes
So
the claim.
if the insured left the watches unattended, there'll be no coverage. So why would your client be?
That's a good question. So my client can control his employees, himself, et cetera, but when he gives it to a consignee, he can't. But the carrier, Judge, the carrier is charging the premium proportionate to the
None
risk.
of that is in the policy. You just wrote that into the policy.
Wrote what into the policy?
Independent versus dependent.
No, but the category of person, the consignee, is not within the control of the insured, and the carrier has separately insured that category, and they charge the premium for whatever risk associated. Thank you, Your Honor.
Cohen versus Cohen.
May it please the court, Gerard Riso for plaintiff appellant Jerry Cohen. Your Honors, the central issue in this case is whether the respondent, as a non-transferee of $2 million of constructively fraudulent conveyances, is liable because he engineered each one of those conveyances, which was of cash, and because he benefited from those conveyances.
So this is a 3211 motion, right?
Yes, Your Honor.
And the judge dismissed all your whole case, right?
Whole case.
So why, at this point where you don't have to prove your whole case, it's a motion to dismiss, should we still be looking at some of these claims? I mean, can you state where in your complaint you put in enough for us to at least say, let's see what happens here?
Yes, Your Honor. The complaint is incredibly detailed. In fact, it was built on many months of judgment enforcement discovery. It was built on the admissions of the respondent in that judgment enforcement discovery, which were in sworn responses to discovery requests.
Why don't, let me give the
deposition testimony.
addendum to specifically focus in as to each transaction. What was the benefit? Because that's the heart of this. Was there a benefit,
To Mr. Cohen.
Mr. Cohen, individually from each of these transactions? What was the benefit that was to him rather than just to the corporation generally, which is not enough under the case?
Yes, Your Honor. The benefit was extraordinary. Within 8 months, all of the money that he took out of the judgment debtors in a so-called windup, while my client, who's an investor, gave $500,000 for an investor note, never got paid back a penny of principal. In a so-called windup, he's ripping all of that money out to a brand new venture that he started. He uses all of the judgment debtors' money as
Could you be a little more concrete to answer the question? Because this is a very granular question. You have to show a concrete benefit. So you're talking in a very broad way.
Right.
Okay, so you're bringing up the $10 million. As to the
right to
10
it.
million, you've mentioned the 10 million, so let's talk about that one. As to the $10 million in profits that you're alleging, the law seems to be, at least there's been some evolution, but that the mere fact that a corporation gets money or makes money is not enough to be a benefit to an individual partial owner of a corporation. You have to show something more than that the corporation made profits or got a benefit. You have to show that the individual somehow received a specific benefit. So how did you do that with the loan and the $10 million of profits?
So the $10 million of profits, which inure to his benefit, is a benefit. There are some cases that say
It's a benefit to the corporation. He's a shareholder. It's a benefit to all the shareholders of the corporation, right? You can't go the second step. There has to be a direct, it's not 7 transfers down the line, it's a direct transfer. So if as a direct transfer, aside from the fact that his shares were more valuable, whatever, what direct benefit did he individually, as opposed to the corporation, get from that transfer?
Well, there was also the subject of the release, which was...
Okay, that's right.
That's a
Hunter, we're
different-
just
that's a
talking
different
about the
claim.
10 million. We're
Yeah,
talking-
you mentioned the 10 million.
Let's move on from the 10 million, because I don't see how that directly benefits. Let's talk about the other things. There was a release and there were some tax benefits, right? What are those? How are they directly benefiting him?
There were also economic benefits, not just tax benefits. So the release of the $776,500 of transfers did a couple of things. It relieved him of his recourse liability that he owed to the entity that the
That's direct to him
That's
personally,
direct.
right? Okay, what else is direct to him personally?
The $300,000 that he took out of the other transferee to pay the personal judgment against him, not the personal judgment, the lawsuit against him.
The Belmont action you're referring to.
And he was a direct defendant in that action, so he could have been
For the
directly.
forgery,
It was
the alleged forgery.
And at that time, the judgment debtors were defunct. He had already ripped all the cash out of them. This other transferee had the cash. He used that money not to pay my client, who was the only investor that he didn't pay. He used it to settle the lawsuit against himself
You want to
personally.
talk about
We think there's an issue
piercing-
of fact that there's no good faith there.
Do you want to talk about piercing the corporate veil too, while you have some time left?
Yes, so on piercing the corporate veil, we think the allegations of the complaint are incredibly detailed on that. He was the managing member of the transferor, of the transferee. He's the one that ran the wind-up. He's the one that did the wind-up. He's the one that made all of the transfers from the transferor to the transferee. He's the one
What
that
was the
controlled the bank
wrong?
accounts. He was the
Assuming there was domination, you have to show that there was a wrong, a fraud perpetrated. What was that?
The wrong was that he put the money in his own pocket or for his own benefit. He didn't pay off the creditors. This is a wind down. You're supposed to take the money in a wind down, and you're supposed to pay the creditors. She's not just a normal creditor. She's an investor who gave him $500,000. She never got a penny of principal back. He defaulted on that note in about a year or so. She's high and dry. Why? His company took all that money. He's doing a wind down, and he's putting all that money into a new entity only for his benefit. The judgment debtors had no interest in that entity. There's no promissory note. There's no agreement to pay interest. In fact, he just wrote it off. There's an email to the account, just write it off. And that's what they did. They wrote it off. Well, you know, you can do that to your company But you can't do it when you're screwing a creditor. When you're doing it to deprive the creditor, the investor, my client, that's tangible harm to my client. The court was wrong when the court found that none of this caused injury to my client. It's the reason why she's not been paid.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Dan Shapiro from Ruskin Moscow Faltacek for the respondent, Jeffrey Cohen. Your Honors, as you pointed out, this was a 3211 motion to dismiss.
So why weren't the allegations of benefit, at least to some of the transactions, sufficient, such as the claim that he got to take tax write-offs that he would not otherwise have been able to take? Why isn't that a sufficient benefit for a fraudulent conveyance claim on a motion to dismiss?
Sure, Your Honor. So the case law in this department and in various other departments, including and also at the Court of Appeals, effectively sets forth the precedent for what would constitute an actionable benefit. And there is case law abound which sets forth that in order for a fraudulent transaction to inure to one's legal benefit, they must actually receive the cash, the asset.
Well, isn't there, I'm sorry, I don't mean to cut you off. Isn't under the old DNC law, 270, isn't a release, your friend discussed the forgiveness of the $760,000 loan and benefit therefrom. Isn't that release of conveyance under the old law?
Your Honor, I believe that misstates the record. There was no release. What my adversary was, I believe, referring to was a tax write-off. There was a loan from one LLC.
But wasn't the tax write-off available because it was forgiveness of a $700,000 loan?
Right.
Which is a release of liability.
And as a result of the forgiveness of indebtedness, my client had to pay substantial tax liability for his.
Okay, but that's a fact issue down the line. The question is that allegation that you got, that your client, that there was a tax benefit that you would not have had except for that transfer, a benefit to you, a direct benefit. And that is, I am 100% sure that that tax benefit is a direct benefit to your client, not the corporation, not anybody else, directly to your benefit.
Well, Your Honor, I don't believe there was a tax benefit. I think.
Well, okay, maybe that's
was
what's alleged. We don't know if that's true.
Well, no.
Right? I mean, we're talking a pre-answer motion to dismiss.
Your Honor, the reason that it's not quite, it is a pre-answer motion to dismiss, and as Mr. Rizzo pointed out, there were months and months and months of post-judgment enforcement discovery, which yielded tax returns which showed my client on a K-1 receiving his member interest apportionate share of a loan forgiveness write-off, and the loan was an entity.
So let me ask you this.
loan.
If you had taken that money and paid the judgment creditor rather than taking the write-off, would your client have had that tax benefit?
One second, Your Honor.
It's a pretty straight, easy question. If you had taken that $700,000, paid the judgment creditor rather than what you did with the money, would your client have still had the same tax benefit?
Yes, he did not receive a tax benefit. That's what I think is being misunderstood.
Well, okay, maybe that's the allegation, which we have to assume is true.
You want to also address to piercing the corporate veil while there's still time why the allegations are not sufficient?
Yes, as I think Your Honor pointed out, to the extent there may have been alleged dominion and control over the transferred funds, none of the transfers were done to.
Why isn't the wrong, as counsel alleged, because this is a motion to dismiss, that you were thwarting the rights of the judgment creditor to be paid on this case?
Because as a result of these alleged fraudulent transfers, 22 out of 23 of the note holding creditors were paid out. Okay, there was one creditor who was not and who refused a settlement. So if this was done to harm the creditors, then that is completely contravened by the fact that.
Isn't that a factual determination? This is a motion to dismiss. There's an allegation that this was all done to thwart the judgment creditor. This particular judgment creditor wasn't paid. Why isn't that sufficient on a motion?
Because we moved pursuant to 3211A1 and 7 and annexed 40 or 50 exhibits which reflect that none of these things actually inured to an actionable benefit to my client. It wasn't, yes, it may have been
I'm talking about
alleged.
piercing the corporate veil now. I'm not talking about benefit. I'm asking about the allegations of piercing the corporate veil.
Yeah, and as we annex to our motion to dismiss, we annex proof of all of the payments that flowed from the transferee entity to note-holding creditors. Okay, the one creditor who did not accept a resolution or a settlement from the LLC transferees happened to be the plaintiff appellant here.
Why did the other side say that you were winding down, they were winding down the judgment debtor corporations? And aren't you obligated when you're winding down to pay off your debts and not to take, including money to the plaintiff investor, and not just to take it and start putting it into all other kinds of settlements or investments or other corporations? I mean, wasn't there a problem with that windup, given this investor was out there?
Well, potentially, yes, Your Honor, and that would give rise to a claim against the LLC. It would not give rise to a claim against the individual respondent here who did not receive any tangible or actionable benefit.
Thank you. Thank you very much.
Just in terms of harm, he even took $100,000 out of one transferee that owed it to the judgment debtors, and he transferred it to his other transferee. That was at the time when my client was the only unpaid investor left hanging. It is a release, Your Honor, because it's in connection with a final tax return, which is a statement to the government that we have no more items of income, we have no more collections, the windup is done, it's complete, that's all in my brief. It's also, the statute of limitation had elapsed by April of 2023. So once they wrote off the obligation that they owed the judgment debtors, the statute of limitations would have barred any claim. That's tantamount to a release, clearly.
How about the $300,000 amount in the Belmont action? Was that a benefit to Cohen?
Yes, because he was sued personally in that action for the forgery. His judgment debtors, they didn't have...
It's not the entity, it was him individually.
Him individually. The judgment debtors didn't have a penny. They were judgment proof. Thank you, Your Honor.
Thank you.
And congratulations.
Thank you. Brown versus Hossein.
Guy Regev of Zerka and Regev for the appellant. Good afternoon and congratulations. And hello. I think that there are two preliminary issues just to make sure we
Do you want to just put that mic
Of course.
pointing towards
There
you
are
a little
two
bit better? Thank you.
preliminary issues.
Go right to a central issue, which is the decision by our court in Sanchez, which involved the same company and the same arbitration clause. And we specifically addressed goals and the arbitration clause and held that the arbitration clause was enforceable. So why isn't that the end of the analysis? Why is this case any different than Sanchez?
Sure. What we see in the analysis in Sanchez and the decision itself is that the issues of authenticity were being addressed, as well as the language
Okay,
barrier.
but I was on Knight, I was on Sanchez. Let's
We were
assume that,
pretty much
right, we're
all
all
on
on that, right.
Sanchez.
So let's assume we're not going to reverse ourselves.
Of
Let's
course.
go to this, let's, right? So assume that we're not going to reverse ourselves. What is different about this case?
Sure. So I must make mention of the two preliminary issues. One of them is that we are actually withdrawing or conceding the fact that authenticity should not be an issue here. I know that was a point we made there. We agree that that should not be, I know it's in our papers, but that should not be the main issue here. So that's number one. The other preliminary issue I wanted to mention is the fact that one of the defendants, I'm sure you may have seen, Dr. Hussein, was actually not even a signatory to the arbitration agreement, and therefore the fact that the lower court actually held that they
I
should
have
be
to
part of it.
ask you though, okay, so yeah, the case was dismissed against the Hossein defendants, right? I'm sorry, the as filed defendants. What is your claim against them? I looked at the complaint. I didn't see any claim against him. What is it?
As being involved in the care surgery over there against Dr.
There are
Hussein.
specific allegations of medical malpractice against them?
Correct, but
Can you
again,
tell me where? Because I didn't see it.
So that is the allegation with regards to Dr. Hussein. The allegation is that he's involved in the actual surgery that took place. But I will say, having just addressed those two preliminary issues about the fact that we are conceding the authenticity issue is not one of the issues to be discussed here. We think that the primary issue here is what constitutes a valid medical malpractice waiver of a jury trial. And
That's what we discussed in Sanchez.
so what
with
we
the
didn't
same
see,
defendant.
so what in Sanchez, the main issue that was discussed in the decision there, we saw that whether or not it was properly authenticated was an issue there, and the language barrier was an issue. What wasn't discussed is the fact that there is a heightened standard in New York, under case law in New York, that the fact that a jury trial is actually being waived should be mentioned in the arbitration agreement.
But
Yes.
the issue here is the decedent was given the document, afforded an opportunity to review the document with clear and unambiguous language saying if there's any kind of issues, and I don't mean to make light of the unfortunate circumstances. Of
course.
It goes to arbitration. Clear in the beginning, clear at the end, bold face, no issue with language, no issue that she signed it. All the other concerns that were enfranchised are not here. So in the face of an unambiguous express provision in their contract, go to arbitration, what is your defense?
So that's exactly our claim here, that the language was not explicit and unambiguous, because the language, when it does not mention, and this is what the Second Department has held, other cases in New York have held, we have all those citations there, they've held that the term medical malpractice needs to be mentioned.
This
number one.
says, this arbitration provision limits your right, including your right to maintain a court action. That couldn't be clearer.
So
What are you saying that is unclear about that?
according to case law in New York,
No, how about the first department? We're not the second department. We've literally
Understood.
ruled on this the last time Goals was up here, that was clear.
so the clarity with regards to mentioning that it's a medical malpractice case that they're waiving it to, and it's a
Counsel,
jury
it says
trial
any-
as well.
Says any claim or controversy. How could it be any more broad? Any claim or controversy means any dispute that arises between us has to go to arbitration. There couldn't be any more broad words that could be used, could there?
So the
You're saying
series
you
of
have to
cases in New
list
York,
every single thing?
no, specifically with
Why
regards to
MedMal as opposed to class action for using bad drugs or some other claim? Why MedMal?
the public policy discussion that was had during those set of decisions is that it's about
Is there
about
anything in the
protecting.
First Department that says that?
There are cases in the lower courts in the First Department.
No, we're not. The lower courts are not the
course.
first. Has this First Department ever said that you have to single out MedMal as opposed to any other claim? That, I mean, many of whom are as or more serious, and say that that has to be specifically delineated in a arbitration clause?
I don't think your
We have
honorable
not,
court
right?
did not
And in
address
fact,
that
we
either.
went the exact other way in our last case.
So that was not discussed within the decision itself, and that's one of the things that I think is in front of this court now, is to ask whether or not patients in New York need to be protected, in that it should be explicitly stated, as other departments have stated as well.
Thank you.
Yep.
Thank you.
Thank you.
Thank you, Your Honors, and may it please the court. And frankly, I think the court has made many of my arguments, and I do want to take this time to respectfully appreciate the fact that the last time that I was here before this court, it was before Your Honor, and again here before Your Honor, and I wish you the best in your future endeavors.
Thank you.
Ultimately, I think the court nailed this on, just hit the nail on the head. This is a very broad, clear arbitration agreement. It's meant to cover all claims. The lower court indicated that. It found that it was broad. It was meant to cover any dispute. It has bold on the top, it has bold on the bottom. It says you're waiving your right to any type of court action. Everything needs to be done in arbitration. It sets forth the location, the jurisdiction, the applicable laws that must apply.
So counsel, what about the other defendants who are not represented here, the ASFAL defendants? I mean, what should happen to them? I don't think they actually moved to dismiss, although it seems like their case got dismissed.
Yes, Your Honor.
It sort of went along with the other defendant.
Yes, Your Honor, and respectfully, I don't believe that I can stand in their shoes here. They had an obligation to move as to the court, to make any arguments. They did not enter an appearance here. They didn't file a brief here. I believe that this matter can be bifurcated. I agree with the court that even reviewing the complaint, I can't figure out what Dr. Hussein is being raised for. Frankly, reading the complaint is very difficult to understand what the allegations are in general. It's done on a very basic notice pleading and somewhat confusing. But ultimately, I think in terms of my client's position, it applies to my client. You want to bring a claim against me, you have to go into arbitration. There's not really an issue. These arguments about substantive unconscionability and contracts of adhesion are just contradicted by the plain language. It's an equal bargaining power. They have the same requirements. They're stuck in the same situation. If my client doesn't like the arbitrator's decision.
Counsel, is it necessary to delineate a medical malpractice case, let's say from a negligence case or breach of contract? You have to delineate every single cause of action that you can think of in that agreement?
I think to do that would create a situation which would just be untenable for anyone. No business that wants to utilize arbitration, because frankly, this is usually in the business context, will want to lay out every single aspect of that. I believe that if this is a scenario where it should be something in an arbitration clause that you must label out medical malpractice, that's for the legislature.
Right, because it doesn't make any sense that medical malpractice, for example, is any more serious than a regular we drop the patient, off the operating table and the patient broke his or her both legs and 2 arms. That's as serious an injury as any medical malpractice injury might be. And I don't think anyone would think that that had to be delineated.
And if I may just add one additional point in there, Your Honor, there are cases where the courts have indicated that certain things must be in arbitration clauses, and that's specifically class action waivers. That went up to the United States Supreme Court, and they ruled that for class action waivers, it needs to be clear and unambiguous in there, because that's a substantive and sometimes a constitutional right. Here we're making it clear, there is a class action waiver. You have to know that there's a class action waiver here. And frankly, it indicates as well, if the courts were to find that the class action waiver is not enforceable, then the whole arbitration clause would also be unenforceable. But in this situation, it's very clear. Thank you very much. And once again, good luck, Your Honor.
Thank you.
I am just going to take advantage of the time to repeat the reasoning used by the second department, which I know it's not, we're not here. And the reasoning, again, is to protect a class of individuals, patients in New York, who are placed in a situation where they have a radically different power dynamic.
But this woman didn't have to go to this. She could have gone to any surgery place. And there's equal bargaining power in that she didn't have to accept this. This wasn't the only person, for a fact, who was doing this procedure. There are thousands of doctors who don't have arbitration agreements who are doing this procedure. She could have gone to any of them. She has perfectly good bargaining power. This is not a contract that it's take it or leave it and you don't get the service.
The question is not whether she had that bargaining power, but rather was she able to understand and be aware of the fact that medical malpractice would be part of it and jury trials would be deprived.
Thank you.
Thank you.
Century First Credit versus Priority Capital. Sorry to keep you waiting, even though you didn't really want to argue.
Okay.
But we wanted to hear from you.
Good afternoon, Your Honors. My name is Brian Grebin. I'm with the law office of Brian L. Grebin. I represent the appellants in the case of Century First versus Priority Capital et al.
Let me ask a specific question. This case was confusing. And we all looked at the complaint. And the complaint with respect to tortious interference with business relation does not assert a direct claim against the individuals. It only asserts a conspiracy. So the only issue before us with respect to the tortious interference with business relation and the individuals is whether there's a valid conspiracy claim. Why is there a valid conspiracy claim against the individual defendants?
Well, Your Honor,
But no direct claim was asserted against them.
Your Honor, and I hope you don't feel like I'm avoiding your question. I just want to set it up properly. The underlying court dismissed the individual liability in general against the two individual.
Right, but we went to go look at the complaint, and the complaint doesn't assert a direct claim. It does assert a direct claim against the individuals for trade misappropriation, but it does not assert a direct claim against the individuals for tortious interference with business relations. So it's just a standalone conspiracy. Why should we allow that?
Well, I do think it alleges.
Doesn't. Doesn't. We looked very carefully.
Cause of action one is only against the corporation.
I realize this is what I'm about to say isn't particularly dispositive. I didn't draft that complaint.
I know, but that's what we're confronted with now.
Yeah.
We're confronted with just a conspiracy claim and no standalone claim, which raises a host of very difficult issues for us as a court in terms of how to approach it, because if we would allow a conspiracy claim to go forward against individuals in a corporation with no substantive claim, we're then allowing a bypass around the whole law of piercing the corporate veil. Because if you could say, well, I don't have any allegations to support piercing the corporate veil, or that the individual's liable because they committed the tort, but I'm going to bring them in a conspiracy, that would sort of undercut the whole purpose of corporations law, which is to protect individuals from liability in most circumstances. So we're now in this dilemma, and I want to hear what your response to that is.
Well, I would like to point out that that argument was not raised either by my adversary or by the underlying court, so I hadn't briefed it. As far as individual...
You didn't even acknowledge in your brief, though, that there was no... I mean, that's a problem. The case is a little, you didn't acknowledge that there's no individual claim for interference with business relations in your brief either. So we're left trying to resolve things without any arguments about anything.
Well, there was what's left in the complaint at this point that we haven't appealed is tortious interference with contractual relations, specifically for the non-solicitation portion of the underlying agreements. And
But there's no... You still haven't answered my question. There's no individual, right now, as the complaint stands, there's no individual claim. So why should we let just the conspiracy claim go forward without an individual claim?
Your Honor, I don't know if I'm misunderstanding you, but are you talking separately from the tortious interference complaint?
I'm talking about the tortious interference as opposed to the trade misappropriation. You did assert an individual claim for the trade misappropriation. You did not for the tortious interference.
Meaning a direct claim.
A direct claim.
A direct claim.
So that's what we are trying to grapple with now in terms of how to resolve this case.
As the officers and as the individuals who were responsible for the specific actions, my understanding is that a corporate officer can be deemed liable for a tort if the tort is...
Right, but then you don't allege that. You still, it's a very simple
That's a direct claim.
It's a very simple question I'm asking you. There's no, because we have no direct claim, why should we allow the conspiracy claim to go forward when there's no direct claim? Yes, you would have had the right to assert a direct claim and allege that they actually participate in the tort, but you didn't do that.
Your Honor, I respectfully disagree. I think we did spell out in great detail about the things these
We're all sitting here telling you we've reviewed the complaint and it doesn't do it. It doesn't
You didn't
say it.
plead that claim directly against the individual defendants. You did not plead. Your first cause of action for tortious interference with contract is only against the corporation. It doesn't add on a separate part that says, and the individuals are liable in addition to the corporation because they personally benefited. So
You know what?
we did
You're
that
not
in the
giving us
eighth.
an answer,
Right.
so you can go. We'll figure out an answer, because we've all asked you in numerous ways, or I've tried to ask you numerous ways, and I'm no closer, to be honest, in receiving an answer from you as to how we grapple with a standalone conspiracy claim. If you want to withdraw the conspiracy claim now and replete it, so you do make a motion down to amend, to assert a direct claim, that might be a wise course of action. Because right now, as it stands, you don't have a direct claim. And we are going to have to deal with the conspiracy without any any direct claim in the analysis.
I
And we're going to
understand.
so hold that there's no direct claim.
I understand, Your Honor, and if I'm not getting it, I do apologize. But there's two things I thought we were arguing here. One was certainly the conspiracy claim. That was the second part. But the first part, and quite frankly, the more important part, is that we don't think the individual defendants should be, actually, we've already settled with the motto, it's just Defendant Woodcock at this point. We don't think individual Defendant Woodcock should be released from his liability for tortious interference.
Okay, we're not going to be able to grapple with that because you didn't assert the claim. So that's where we are. So thank you.
Thank you, Your Honor.
People versus Cuevas?
Good afternoon. Rachel Lindy from the Office of the Appellate Defender on behalf of Manuel Cuevas. Manuel Cuevas' current prison sentence is unduly harsh and excessive, unnecessarily prolonging his separation from his children. As an initial matter, it is
So one of your main arguments is that he wants to go back to the DR, but in the record is the statement that he was released once before and went to the DR and came back illegally within a year. So why wouldn't we just be concerned that he might do the same thing again if we let him out early to go back to the DR?
While that is the case, it's also the case that significant time has passed since then.
But
He
he's
is
actually
now,
done it before.
and
Come
he,
back after he was released.
He was released from prison, he was deported, and he illegally came back to the US, right?
So that's your main argument, that we should reduce the sentence so we could go back to the DR, but it's a strange record to make that request on, to be honest, since there's already an instance of him coming back after he was deported.
and that is the case, and it's also the case that he is now almost 40 years old, and he has spent
You're saying he won't do it again? He did it once, but he's not going to do it this time. This time he's going to stay in the DR. Things have changed.
Well, he is certainly subject to deportation upon his release.
Right, but you're saying that even though once before he was deported and came back, we should assume he's not going to do it again this time, right?
Your Honor, he's continuing to be incarcerated. Mr. Cuevas has already spent over 7.5 years incarcerated. His guilty plea was to a term of 8 years. However, he is not subject to release for another 1.5 years as a result of a discretionary decision on the part of docs. And he is certainly subject to deportation upon his release. But nevertheless, he is subject to significant further incarceration at a time when the New York State prison system is in crisis. He is incarcerated at Wallkill Correctional Facility that does not currently have access to clean water. There is water contamination there. And his prolonged incarceration in this overburdened prison system, where the system statewide is suffering a significant staffing shortage, when at the conclusion of his term of incarceration, he will certainly face deportation, is an additional burden not only on a risk to his own safety, but it's also a risk to the safety of prison staff. It's substantially costly to the taxpayers of New York.
That's sort of like a general policy, which we don't get involved in an individual's sentencing. Every prisoner, right, every person incarcerated has that same argument. So I would prefer if you did it directly with respect to what's different about your client.
Sure. So one thing I think that this court should consider is the facts of his criminal possession of a weapon conviction, which is the sole violent felony conviction barring his consideration for early release for deportation purposes, which of course would be a discretionary decision on the part of docs, but he is not able to be considered for that early release for deportation because of this violent felony conviction, even though in this instance, what he was convicted of was having a a gun found factually unloaded beneath the stove in his apartment that there is no allegation or evidence in fact belonged to him, which is a far cry from the public carry of a loaded weapon, and courts have recognized in the past that that is mitigating and reduced sentences accordingly. Thank you.
Good afternoon, Your Honors. May it please the court. Jennifer Mitchell for the people. Defendant's bargain for sentence was fair and appropriate in this case and should not be disturbed on appeal. This was a very serious drug crime, as well as the weapon possession conviction stemming from narcotics detectives recovering extremely large quantities of drugs from defendant's apartment. And in that apartment, they also found a weapon with 15 rounds of ammunition located directly next to it. Defendant was facing very serious charges for this crime.
This was his second felony conviction here?
Yes, Your Honor, this was his second drug felony.
Right.
Yes, that's correct.
And the first one, he was deported?
That's correct, Your Honor. He was
came
deported
back illegally?
back in 2016 and then re-entered the United States in 2017.
Illegally or
Illegally, yes, Your Honor. And so defendant's arguments now asking to be reunited with his children in the Dominican Republic are...
Were his children alive when the first time he was deported?
I believe they were, Your Honor. I would need to double check the record, but I believe that is the case.
So to be clear, it looks like they recovered approximately almost 6,000 pills of fentanyl. I think the allegation was that he had a distribution network in his apartment. Isn't that correct?
That's correct, Your Honor.
It wasn't just a mere one packet. They found the distribution network.
Correct. There were almost, as you said, almost 6,000 pills of fentanyl, 450 grams approximately of heroin, not to mention almost 1,000 grams of methamphetamine, and that's just to
Can
name
you remind me of the minimum and the maximum that he was subjected to?
Yes, Your Honor. So the defendant was facing, the maximum was between an indeterminate term of 12 and 24 years on the A1 felony of...
Was it 12? I thought it was...
I would need to double check the minimum, Your Honor. To be honest with you, I don't know it off the top of my head. But I do know he was facing, just on that top count alone, between 12 and 24 years. And so his aggregate 8-year sentence that he received was very fair and appropriate in this case, and there is no reason for this
Can I
court
touch
to reduce
upon the weapon? Because counsel talked about it being unloaded. Isn't it true in the same open closet where a child could have been, there was 15 rounds of ammunition?
Yes, Your Honor. They were found directly next to the gun. So legally speaking, this was a loaded weapon, as per the...
But it was nearby. It wasn't just like there was no ammunition in the closet. It was together.
It was together, yes. The gun was found, I believe it was found on the floor under the stove, or so. I may have that fact off, Your Honor, but the gun was found directly next to the ammunition. So...
I'm sorry, just to clear this up or round out the discussion, the appeal waiver on page 8 of the record, in reading how the judge allocated that issue, the judge didn't advise him he had the right to counsel, correct? I could read it for you. He was not advised that if he couldn't afford a lawyer, he would have the right to counsel for the appeal, correct?
Yes, Your Honor.
The judge missed that. The judge didn't break down all the issues that would survive the waiver.
Yes, Your Honor. The people are not...
So you're not really challenging their right to at least come before this court to ask for a reduction of the sentence?
Sure. They of course, have the option to come before this court and ask for a sentence reduction. It's simply our position that that is not appropriate.
You're not relying on the waiver.
Exactly, Your Honor. We are not relying on the waiver in this case.
Fair enough.
Thank you so much.
Thank you.
Counsel, I just want to ask you two things quick. First, was the minimum 12 to 24? Do you agree with that? And he got 8?
So had he been convicted of the top charge after trial?
It was 12 to 24?
I believe that was the range of the sentencing exposure.
8. And then were his children alive the first time he went back to the?
His youngest child was still an infant at the time of his
Oh,
arrest.
they were alive.
In
They
the,
were
in the
all
current in the current. No, his youngest child was not yet alive.
Okay.
Previously.
So, but there were, he did have children in the Dominican Republic the first time he went back to the Dominican Republic?
He did, yes. And since then he's missed his youngest child's entire life. And again, Mr. Cuevas does not dispute the severity of the charges against him. He acknowledges and took accountability for the charges for the drug conviction. And at bottom here, he really is just seeking the benefit of his bargain, which is a sentence of 8 years incarceration. Again, at this point, he's been incarcerated for 7.5 years, but he will not be eligible for release until after 9 years of incarceration. Thank you, and congratulations.
Brittany versus Miles Gustav.
Good afternoon, and may it please the court. Ethan Singer for the petitioner, Ms. W. There is no substantial evidence to support the state's determination that Ms. W, a survivor of years of brutal and repeated domestic violence, maltreated her child in September 2017 when she was beaten unconscious by the man who had previously kidnapped her, sexually trafficked her, and repeatedly attacked and
So
assaulted her.
what does the evidence, in your opinion, show as to what exactly happened on that particular September 2017 date? Did she have the child with her?
Are you talking about when Mr. B unexpectedly confronted her at the domestic
This is
violence
so he comes to the shelter, right?
So what the evidence shows is that he unexpectedly surprised her at the shelter that she had been working to keep confidential.
So her allegation was that he got the address from someone else, but she did not give it to him?
Right. She does not know how he found the location, but as she testified, she was even trying to keep it confidential from her friend that she was with at the time. And when he showed up, the first thing that he demanded was that she go and retrieve their child with him. And so she was confronted with this basically impossible choice, keeping in mind that the last time something like this happened, he said, "I'm glad you showed up, otherwise I would have stabbed you to death." And the previous times in which she tried to run away from him, in her words, he, quote, caught up with her and beat the crap out of her. She was faced with this choice of either deciding to say no and risk that brutal beating or risk being stabbed to death, or she could go with him to retrieve the child and do her best to keep the child safe that way. But these circumstances were something that the ALJ completely failed to even consider. The ALJ, instead of considering the circumstances then and there existing as prescribed by Nicholson, cited options available such as postnatal care and counseling, something that no reasonable person can conclude were available to help Ms. W in that moment when she was confronted by Mr. B at the shelter.
I just want to clear my head. On appeal now, you're solely focused on the September 2017 incident. That particular
Yes, Your Honor.
report.
There were 3
You're
indicative
not really
reports.
getting caught up with 2015 or any other type of.
Right. We're challenging this September 2017 incident because that was roughly 6 months after Ms. W was able to separate from Mr. B and she was seeking out services in the domestic violence shelter.
She's not even at the shelter when he shows up, right?
Right. She was with her friend.
testifies she's not at the shelter. She doesn't have to go to the shelter. He shows up at the shelter and she's not there. And she testifies, for some reason, I don't know why, I walk back to the shelter to meet him. It's not like he confronted her at the shelter. She wasn't there. So he calls her and says, I'm at the shelter, and she makes the decision not to stay wherever she is. He doesn't know where she is. She decides, and she testifies straight up, I don't know why I did this. I walked back to the shelter to see him, right?
Yes,
Is
Your
that the
Honor.
testimony?
Yes, Your Honor.
That's not him confronting her at the shelter. That's her going to the shelter after he called her and said he was there. That's a whole different scenario, right?
Respectfully, Your Honor, I'm not sure I'd agree that's a whole different scenario. First, what we're challenging is the agency's determination, because their decision can only be affirmed on the grounds that Jay chose, not on alternative grounds that the reviewing court considers to be more appropriate. And what the agency found to be unreasonable was her leaving the domestic violence shelter, not going to see him in front of the shelter. But if they did consider the circumstances, it's completely reasonable for someone who in the past was threatened that someone would stab her to death if she didn't come and see him, to go and see if he was actually there. And it's completely reasonable for her to go to the shelter that she thinks is a safe spot to see if it's still safe. What is she supposed to do?
Remind me how she testified she found out that he was at the shelter if she was not at that time at the shelter.
So she received a call.
She was at her aunt's house?
No, we don't know where she was. She was not at the shelter that she was riding with. She was with a friend, not at the shelter, precisely because she wanted to keep its location confidential even from her. She received a call. She was surprised that it was him because she thought she had severed contact with him. And it's Mr. B saying, "I'm outside the shelter." And she says, yes, that she felt compelled for some strange reasons, but I disagree with that.
She just said she didn't say anything about being compelled. She said, for some strange reason, I'm reading literally her testimony. For some strange reason, she went back to see him. And the child wasn't there. She went and got the child, right? The child wasn't at the shelter. She wasn't at the shelter.
Yeah, well, this alternative ground that the ALJ didn't decide on, I would say it was reasonable for someone to go back to their home to see if their abuser had breached the confidentiality of it that they'd been trying to keep for the last 6 months.
So moving a little further, is the red light on?
It is, but go ahead.
Go to where they were battling it out at the aunt's house with the child. What is your understanding of what took place there?
So my understanding of what took place at the aunt's house is that when she got there, Mr. B started drinking, and then he brutally beat her. And that's the other point. That even aside from this point of minimum degree of care, there's a separate independent ground to reverse the ALJ's decision, and that's that the child wasn't in imminent danger of harm. The only evidence that the ALJ bases its decision on is this multiple level of hearsay that Miss W is holding the child. But the only testimony at the fair hearing has nothing to do with her holding the child. She described herself being brutally beating. That's entirely inconsistent with the child emerging unharmed. ACS was...
I'm sorry.
Just the hearsay about the child being in danger came from an anonymous phone call. We're not sure who from, or
We know that it was from Mr. B's own family member because at the fair hearing, ACS accidentally read from the unredacted report. And then also in the state's answer at the lower court, they also admitted that it was from Mr. B's own family member. And the record is clear that only Mr. B's family members were at that house aside from Miss W, Your Honor.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Joshua Cohen for the State Respondent, Office of Children and Family Services. Substantial evidence supports the determination that petitioner maltreated her daughter by removing her from safety and bringing her into the same home as the child's abusive father. The petitioner did this despite the father's extensive history of abusing the petitioner and maltreating all 4 of the petitioner's children, and she did it despite the ample resources available to her.
what were the ample resources available to her?
The undisputed circumstances here, the ALJ was presented with 2 differing stories, but the undisputed circumstances here are that she was in a safe location, her daughter was in a separate safe location, she was not near her abuser, she had her cell phone, she was in public, it was in daytime. Even once she got to the front of the domestic violence shelter, she was in front of a domestic violence shelter. And she didn't, unlike many of the cases that petitioner relies on, she didn't have her child with her at that time to worry about. She was in front of a domestic violence shelter in public, in broad daylight. And even if he had discovered that location and that particular shelter was no longer a safe place for her, she could have gone inside and gotten services. She could have, even before she went to the shelter, called the police because there was an order of protection against him, and he was violating it by simply calling her, let alone trying to contact her in front of the shelter. So she had many resources and options available.
You said that the child was somewhere else. So how was the child in danger for that incident?
The child was not in danger until the petitioner left the front of the domestic violence shelter and picked up her daughter from a safe place and brought her into an unsafe situation. That's the main reason why there's maltreatment here. That is maltreatment.
That was at the father's aunt's house? Is that where this?
No, Your Honor, it was at the petitioner. The child was safe at the petitioner's aunt's house, and the petitioner removed her daughter from that aunt's house and brought her to the father's aunt's house. And that was an unsafe situation.
That's where, at the father's aunt's house, is where the fight happened.
Is that where this situation occurred, this altercation between the mother and the father?
Yeah, yes, Your Honor. The fight occurred at the father's aunt's house. So the petitioner had already removed her daughter from safety. She was safe at her aunt's house, which is where her other 3 children live.
Can I ask you, there was a police report about that, correct?
Yes, that's right, Your
And
Honor.
the police report says that they were both drunk and that they were involved in a physical alteration while the mother was holding the child in her arms, right?
That's correct, Your Honor.
That's what the police report says.
That's correct, Your Honor. And I'd like to briefly address this allegation that the source is somehow biased or unreliable. That's not borne out by the record. This source was doing the responsible thing here. And even if she's related to the father, there's no indication that she demonstrated any bias toward him. She called the statewide central register on both the petitioner and the father. She called the police on both the petitioner and the father. And she expressed concern about what to do if either the petitioner or the father returned to try to pick up the child. So it's just simply not borne out by the record that she's somehow biased just because she might have been related to the father.
Thank you.
Thank you, Your Honors. I respectfully ask that this court confirm the determination and dismiss the petition.
Good afternoon, Your Honors. May it please the court. My name is Elizabeth Friedman, and I am appearing for the city respondent. Your Honor, we concur with everything that the state respondent has argued, and we agree that if not dismissed against ACS, the city respondent, then the ALJ's determination should be confirmed based upon all of the evidence in the record. I just like to emphasize that it is undisputed that the mother took the baby from safety, took that baby, brought the baby to an unsafe situation, which was her abuser's relative's house, where the abuser was. And that was part of the unsafe situation that the mother voluntarily entered into with the baby, and then at that point, after getting drunk, the abuser subsequently assaulted her, placing the child in an unsafe situation. The ALJ's determination should be confirmed.
And she got a certificate she got a certificate allowing her to work, right, in the job that she's in now, correct? So
I'm sorry, could you please repeat that?
Didn't she get she did get partial relief.
The mother, right, the report of maltreatment was found not to be related to
Right,
care.
right.
And also the one of the allegations of maltreatment was there was no evidence as to that. Nothing was presented as to that, so that was dismissed.
Okay.
Thank you, Your Honor.
Thank you.
Could you answer this question for me? Assuming we confirm the September 2017 findings, what's the prejudice to your client? Where is the
Yeah, well, there's a stigma associated with this because she strongly believes that she did not maltreat her child when she was beaten unconscious. And I don't know the case off the top of my head, but I believe there is case law that's found that this stigma is a justiciable issue. And also, if something unfortunate were ever to happen again, that could be something that the court could consider, just like I believe the court is talking about these other instances of maltreatment. But the main point I'd like, if that answers your question, the main point I'd like to emphasize on rebuttal is that the respondents come up here and say that it's undisputed that Miss W removed her child from an unsafe location, but what they're failing to do is grapple with what Nicholson is requiring the ALJ to do. The question is whether it was reasonable for her under the circumstances when she was confronted by Mr. B to leave that shelter. I urge you to read Elizabeth B, which provides that the reasonable care standard can be modified because a parent is under stress or fear. the ALJ here in response are doing are just generalizing and saying that it's completely unreasonable to leave these
So in other words, it's your position that if a mother believes that in this case, the father is threatening her life, that she then is doing the right thing by taking her child from a safe place and bringing a child to an unsafe place, to put that child at risk because her own life is at risk. Are you suggesting that that's what should be done here?
I'm saying that is what Nicholson requires to be done. Nicholson requires you to consider risk.
I think we read it a little differently, right?
Thank you very much for your excellent pro bono representation in this matter. The court
Thank you, Your Honor, and
appreciates it.
congratulations.
Thank you. And the last case on the calendar today is Callan versus RCB3 nominee.
Good afternoon. May it please the court. Seth Frankel for the appellants. Congratulations, Justice Kern. I apologize that it looks like your last argument from the bench. You have to listen to me, but what we have here is ostensibly a 240 case, but I want to take a step back from 240. I think I'm as guilty as anyone of getting blinders on with 240, and the real issue is credibility and deciding credibility on summary judgment, because what we have here is two versions of an accident. One, right after an accident, the plaintiff's given an opportunity to prepare a written statement, and he writes that he missed a step on an 8-foot ladder, and that's it. That's the end of it. And this isn't
But then under oath,
under oath, correct? Yes.
just bear with me, on page 402 of the record, he's very clear where he says, I felt the ladder shift a little as I was coming down. And he repeats the same concept in the C3 form later on. So we have consistency here. And the fact that he may have missed one particular point in the process in the initial accident report it's not a glaring inconsistency here for your purposes.
Well, I disagree with that. I think it is a glaring inconsistency because in the incident report version where, again, this isn't like he's on a stretcher getting wheeled out and he just, jots something down. He's on the site for an hour and a half. He says he didn't have an ambulance take him. He walked off the site on his own power. He waited for his son to come pick him up. He's got plenty of time to write it doesn't even have to have that much more detail, but it is the single point that takes this from a 240 case to not a 240 case. So it is, in my mind, a glaring inconsistency. I liken it to, if we take, again, out of the construction context, let's say we have a motor vehicle accident. Guy admits to the police officer that he stopped short. But then under oath a year later.
Go back to the labor law cases because we have lots
Sure,
of them
yeah, of
rather than
course.
going to a different type of case. I've done a lot of them.
I know.
You look here in front of me, and I appreciate seeing you here. But nonetheless,
Congratulations to you on your seat on the bench.
Thank you. Let's talk about Garcia versus the Church of St. Joseph. It was cited. In that case, we had the plaintiff testifying the ladder shifted. And there was an argument similar to here that the plaintiff had told his employer that he fell when attempting to descend the ladder. And we found in Garcia that was not inconsistent.
Okay. I'm not arguing that the deposition version falls outside of 240. I can't make that argument with a straight face.
Thank you for being intellectually honest.
I try. But I go back to a few arguments ago, actually. Justice Scarpella, you had said, why don't we let the jury decide that inconsistency? And that was on the other construction case. Maybe an hour got another time blurs together. But that, I think, is the central issue, is that the credibility determination that was made by the Supreme Court.
The problem with that argument in this case is that it's not inconsistent. You say he just didn't add that second part in. That's not inconsistent. He did say, he says on that day, missed the step, fell and twisted my leg. A couple of days later, he files a report. He said, the ladder shifts, I twist my leg, I miss a step. That's not inconsistent. It's just there's one little part of it that you're saying is because it's missing, it creates an inconsistency. But does it?
Well, I think,
I mean, he's always, from day one, he said, I missed a step, I fell off the ladder and twisted. 2 out of the 3 times he has added in because the reason why was because the ladder shifted. And you're saying because that one time you didn't also say because the ladder shifted, there's a credibility issue. And I think we have a lot of cases that say that that doesn't really raise a
sure,
credibility.
and I understand that. And
You
I
understand that,
I just don't think it's a little detail. I think it's a big detail. I mean, 2 weeks ago, I missed a step in my house. It's not a 240 case, it happens. And anyway, I see my light is on, so I should probably quickly address the indemnity very quickly. I think if we look at the contracts in total, one of the problems in the court below was that it was treated globally between both RCB3 and Tishman. RCB3 is named in the subcontract. I know it says GID development.
But is there anything here, maybe I missed it, so you can help me out. Is there a way that you, based on personal information on this record, that links GID with Tishman and RCB3?
Yes, on page, I believe it's 115, the RCB3 contract with Tishman says RCB3 care of GID development.
I understand
making them
that,
one and the same.
But that doesn't help in terms of the ultimate agreement in the subcontract where it only just lists GID.
It also refers to parents and subsidiaries, the indemnity agreement.
Thank you.
Thank you.
Good afternoon. May it please the court, Michael Cassell from Mr. Callan. In this situation, this court, as the court has alluded to, has consistently held there's inconsistent versions. If my client said I was walking on the ground and I twisted my knee, that's an inconsistent. This court has held time and time again a statement that the plaintiff is missing because he's told, and it's on page 418, he's told to write down a summary as to what happened here, which he does. It would almost incentivize defendants to say to a plaintiff after an accident, just give me limited details, because then we're going to use it against you. This court has held time and time again in Ping Lin, Wazalewski, I believe just a couple months ago in Eisner, E-I-S-N-E-R, all hold the same thing. The statement says, I was on a ladder, I got injured, I fell off the ladder, and he testified, consistently at his deposition, I fell because the ladder moved. We have the C3 6 days later. All of that consistent with this case was enough for summary judgment, and it should be affirmed. All right. Thank you. Congratulations, Your Honor.
Thank you.
Your Honors. May it please the court, Lawrence Getzler on behalf of J&L Electrical. The premises was owned by RCB. RCB then hired Tishman to provide construction services. Tishman subcontracted mechanical work to non-party JPR. JPR then subcontracts to Automated. Automated subcontracts electrical work to my client, J&L. The Automated J&L written agreement does not contemplate indemnity for RCB3 or Tishman.
They don't even mention them in there.
It doesn't even mention it.
I guess by the time they got to you, you had no idea who was the owner or where you were even working, but it mentioned GID, which was not the owner or the GC.
Correct. It doesn't mention Tishman or RCB3. So based on the express terms of the subcontract and the deposition testimony of my client, J&L, who, Mr. Garcia, he was the owner of J&L, and he signed the written agreement with J&L. The express and unambiguous terms of the subcontract does not confer any express or implied right of indemnification in favor of RCB3 or Tishman. They are not named or defined in the contract between Automated and J&L. Finally, light's not on, good. As Judge Cohn's decision noted, in the deposition of Tishman, the safety director was testified. He was unfamiliar with Automated. He didn't even know that J&L was on this job. And the J&L deposition testimony of George Garcia, the owner of J&L. He did not even know if of J&L, and yes, he did not know if J&L even worked for Tishman. He was unfamiliar with JPR, and the JPR automated contract is between two non-parties. It's unauthenticated by any person with knowledge of the contract. Finally, the automated J&L contract lists the owner as non-party GID Development, and the contractor is identified as JPR.
Thank you.
Thank you.
Not really much to add, just to say there's one point in the J&L's brief where they said there was no finding of negligence. And I'd just like to point out that if we get over that hurdle, this involves a J&L employee, a J&L ladder. In the plaintiff's testimony, he said he set up the ladder, he inspected the ladder before, and 200 has been dismissed against RCB3 and Tishman. So to the extent that we get over that initial hurdle, I don't think negligence against J&L is an issue in any way. Thank you.
Thank you very much.